Hi, welcome to the One Voice Washington, D.C. update, where we give you federal government policy developments as they happen. And today, I'm Paul Nathanson. I'm with the Policy Resolution Group at Bracewell. I'm solo today as Caitlin is out and about. And as always, this presentation is also brought to you by Omar Nashashibi and John Guzik, your advocacy firm, the Franklin Partnership. So let's get right to it. We have a very busy agenda today. We are going to talk about developments in the U.S. Congress, obviously including the what's up with the tax bill in the Senate. We have several regulatory updates, including the release of the final overtime rule, and I'll get to more why we're going to be seeing so many rules released soon. But you can see here for when you download this PowerPoint and you want to share this with others, this is a list of things we're going to talk about, and this is why Omar is so amazing that he gets through this in 30 minutes. One of the things is April brings showers, but also brings regulatory rules because of the Congressional Review Act, which I'll let my colleagues explain. But there's a lot of rules that we need to that have been proposed that are in there, actually not proposed, that they're in the final stages. The final rules are out, and Omar will talk about the relevant ones along with John. And then we're going to talk a little bit about trade and supply chain policy. Obviously, a lot of you are, or some of you are familiar with these issues because you were in Washington. We had a nice group of NTMA and PMA members who came in for our annual Washington legislative fly-in, our One Voice fly-in, where we had some really good meetings on the House and Senate side, both with congressional staff and members, and members coming to our congressional reception. So really, there is no substitute for our manufacturers talking directly with our elected officials about these issues. And so it was a really great day and a half in Washington, D.C. So thank you all for those of you who participated in your support. So I'm going to turn it over to John to get us started about what's happening in the U.S. Congress.
Well, thanks, Paul. For those who did come to Washington for the fly-in, they realized that some of their meetings were canceled or moved around because a lot of cabinet secretaries, high-level administration officials are trudging over the Hill for hearings on their budgets. So they're begging and pleading with members of the House of Representatives and the Senate and their senators to get their budgets allocated properly. On the House side, the House appropriations process is starting a little slow. We have a new chairman of the House Appropriations Committee, and so the appropriations requests are due. So they are going to try to streamline and speed up the process, the appropriations process moving forward, so we don't deal with continuing resolutions like we've seen for the past several years. The Senate is continuing to work on the Federal Aviation Administration authorization. This expires at the end of the month. They're out of session today. They don't come back till Tuesday. I'm not very optimistic. This has become a political hot potato. What a surprise. And they may have to do a week-long extension of FAA, but we'll see. And after that, Senate Majority Leader Chuck Schumer wants to continue working on, banking legislation or cyber security legislation. But as Paul mentioned, the big issue that we hear a lot from our manufacturers. So what is the latest on the tax bill? Well, it remains stalled in the United States Senate. There's a handful of Republican objections continue. Some Senate Republicans want changes to the child tax credit. Others didn't like the fact that this tax deal was negotiated between Ways and Means Committee Chairman and Senate Finance Committee Chairman, and they want the full committee to have a markup, so they are concerned about the process. And others, want amendments, for their pet projects to be voted on the Senate floor if they do take this up. So it's still, very uncertain right now. There was brief discussions, and I think we've mentioned in last month's webinar that there may be a possibility of attaching it to the FAA reauthorization. That's not going to happen. FAA has become a political hot potato, and so that's not going to happen. But if we don't pass this, if the Congress does not move this tax bill by Memorial Day, it's unlikely that we're going to have a tax bill in tax year 2024. So in preparation for what happens in 2025, and as we've mentioned in the past, the Tax Cuts and Jobs Act, which was the Trump tax cuts, there's a number of expiring provisions at the end of 2025, and many of them that are important to NTMA and PMA members, whether it's Section 199, obviously continuing dealing with bonus and research and development tax credit. So the Republicans on the Ways and Means Committee have put together tax teams. They put together 10 tax teams on various issues. They're going to specialize areas of interest where they're going to study what tax provisions should be addressed when the Congress comes back in early 2025. They're going to likely hold hearings around the country to get testimony from individuals. And so that is what we're looking at.
Yeah, what their plan is with regards to this is, because I was on a call with the guy that runs the committee this yesterday afternoon, and the plan is, as John mentioned, they've got their 10 tax teams. They're split up, and we'll talk on the next slide about the different groups here, and you'll take a look at it. But the goal is that some point towards the end of this year, before the election, that some of the groups will issue a report, some will issue a white paper, some might issue some actual legislative language. There isn't going to be a set policy that comes out of it necessarily on each individual subject matter, as some will just be out there just gathering more information about what could and could not be included in the next round of a potential tax bill that they have to do in 2025, with the idea being, if Republicans are in charge of the House, that this work product would end up being the baseline to move forward with those kinds of updates that they're going to try to do. For example, you've got research and development comes up under one of the categories. You've got 199A, which is your pass-through deduction. That actually ends up being under the Main Street, not under the manufacturing, one of the tax teams that's under there. They're also going to be looking at 529s expansions. And as John mentioned, you've got bonus depreciation, CapEx, that falls up under a separate one as well. Global competitiveness will deal with a lot on oil and gas and energy supplies as well, and overseas supply lines. So as you can see, that they've kind of broken this up in a number of ways, with the idea of having towards the end of this year at least some kind of a baseline of a work product with some other hearings going through this year is the expectation.
Omar, let's talk about regulations.
Yep, that's right. As Paul mentioned, there's quite a bit going on right now, and we'll just start with the overtime rule. That is the big one that we've been telling folks have been coming out for some time. The rule has now come out. It is final, and it is out as of April 23rd, a few weeks ago, making over 3 million, almost 4 million workers eligible for time and a half effective next year. This is moving in a couple of stages, how they ended up doing it. And to clarify, this is for full-time salaried employees that are executive, administrative, professional, or clerical, as we define them as EAPs. It does not make changes to the duties test, but it would increase the current threshold that Trump increased it to. 35,568 is the current threshold, starting on July 1st. So just in less than 60 days from now, that threshold would go up to 43,888, meaning your employees that are full-time salaried, EAPC, would be eligible for time and a half up to that 43,888. Then in 6 months later, on January 1st of 2025, it goes all the way up to 58,656 to make those eligible for time and a half. In addition, there's an additional category that comes in that is called the highly compensated employee, and that increases from 107,432, which is the current level for those subject to time and a half for total compensation, to 151,164. Again, that's time and a half. In that one, it's not going to cover engineers. Most of the time, your engineers are going to be classified as an accountant or a doctor, dentist, attorney, so on and so forth. So they are not typically eligible, but in some cases they still may be as well. So that's something to watch from the HCE standpoint, the highly compensated employees. And then it is slated to go ahead and increase every 3 years starting in 2027 and being adjusted to the 35th percentile of the Southern, or what end up being the Southern Census Review Bureau. So ultimately what this could do is by the end of the decade, have you at roughly $70,000 or so and below would be eligible for time and a half. And again, not taking a position on whether or not people should earn that. It's more of helping you plan and understanding the timelines and the deadlines that are coming in here with regards to under FILSA and the overtime protections with regard to an executive, administrative, and professional that's involved in there. Again, they have to be paid a salary. They have to have a specified salary, which means it's not going to fluctuate as an hourly might, and that they also perform those executive, administrative, professional, which also means clerical duties as well in some cases. And that's where they have these numbers coming back. And here's just a quick next slide is the FAQ, but this will give you a quick snapshot of what the standard looks like as the standard salary level. That increases again from that 35,568, and then July 1st, less than 60 days from now, that's an increase, and then another jump after that. What's important to do is certainly work with your HR folks, work with people that if you might have somebody that is eligible for the overtime increase and they are partnering with somebody on the production side of the facility, potentially on a job that might increase their hours, to start tracking, start thinking, having those conversations internally about new hires, what are starting salaries, especially knowing that they are going to be increased every so often there, every 3 years, as it said at the bottom of that previous slide. And then they'll also have the additional FAQs where they do mention here that at least 150 days prior to the date of a scheduled update for the standard salary and the HCE total compensation requirements, that they will publish in the Federal Register a notice with those new earning levels. So giving you at least 150 days, that's frankly a lot more than they just gave you now for the most recent updates for the July 1st. But now is the time to start having conversations about those. And for more information, again, take a look at with regards to the FAQ there. And this one we found interesting on question 19, that the OSHA, excuse me, not OSHA, but the Wage and Hour Division put forth at the Labor Department, was about how employers have a range of options for responding to the updated threshold established by the rule, whether it's increasing the salary of the employees to at least a new salary level to keep that exempt status, pay the overtime premium, reduce or eliminate overtime hours, reduce the amount of pay allocated to base salary, use combination, reclassifications. So we thought it was interesting that they're spelling out for you what your options are. As always, please consult with your labor counsel prior to taking any action on that. Lastly, though, before we leave the overtime rule, there likely are going to be some legal challenges. Most legal folks that we've heard from indicate that it is the 3-year automatic increase that might be the one that's the part of this is most susceptible to a legal challenge. Although if you notice in the actual rule itself, the Labor Department says using whatever methodology to establish the baseline for an increase in use at the time. So that is giving them even additional flexibility to modify it later on through a notice and comment period. Another one we mentioned last month is on the OSHA worker walkaround. This is known as the third-party rule, that where now OSHA's final rule taking effect at the end of this month on May 31st will allow employees or an employee to request an individual or multiple individuals that are non-employee third parties to accompany an OSHA inspector on their worker walkaround. In that inspection as well, those third parties are not limited to persons that have formal credentials, such as an industrial hygienist, a safety engineer, or have a particular expertise in that industry. As we mentioned previously, the individual could also be an activist, could be an attorney, could be a union organizer, even if you're not a union shop. And you can also have more than one union representative, or more than one employee representative based on the requests that are there. What the FAQ that was just released that came out is helpful with, and again, speak to your labor counsel on this, speaks to guidance about what you can and cannot do in terms of requirements about that third party when they come in. Attorney briefing that we were on recently indicated that you should see is that individual already written into the warrant, and so if they are, then talk about how admission. But you certainly can and make them required to take precautions, any PPE that's required, safety orientations, briefings, NDAs, relinquish the use of personal cameras and equipment that could be used for recording, any other policies that you already have in place, but that are not used then to discriminate in any way against that individual, because that conduct could then be considered obstructive and interference with the inspection. So they're basically saying don't make things up to make it harder to let that person enter, follow the normal procedure and guidelines, and make sure that they are complying with everything as well, and documenting that, and of course call your lawyer first. And the other FAQ question here that they recommend is with regards to, can they require a confidentiality agreement be signed? In that OSHA does believe that they will have to comply again with those established rules and policies if they are equally applied to all visitors. So keep that in mind. If you do have visitors that are, if you do require visitors to sign confidentiality agreements, then yes, you likely would be able to do so with that third-party rep. But if it's not a reasonable request, then that may fall into an obstruction area as well. We want to give you a preview. We've been having spoken about the OSHA indoor heat rule for some time. As a reminder, OSHA last fall started working on an indoor and outdoor heat rule for when the 80-degree heat index reaches or exceeds 80 degrees Fahrenheit, and they would prescribe a number of different requirements in the workplaces. As we'd mentioned, we had expected some movement by Memorial Day of this year, and we are starting to see that. The Department of Labor's OSHA has a number of different advisory committees. One of them is this one here, the Advisory Committee on Construction Safety and Health, and they met last week on April 24th, where they unanimously recommended that OSHA move forward with a proposed indoor and outdoor work settings proposal on heat injury, illness, and prevention. We mentioned this because in the coming week on May 7th, the NACOSH, the National Advisory Commission on Safety and Health, which is one of the larger and more significant advisory committees to OSHA, is also slated to consider and recommend that OSHA move forward with a proposed heat rule. So we do expect at our next webinar to provide you an update on that one as well. As we've mentioned, we do have a new system that's in place for recording and reporting in terms of who's required for your 300As, your 300s and 301s based on company size. We have that data. We mentioned this way back during the Obama era, that electronic gathering of this information from OSHA would end up leading to public dissemination, oftentimes without explanation, and that link below will get you down into that. Just note that data is now out there. One issue that generated a lot of headlines as well in the previous weeks was on April 23rd, the Federal Trade Commission voted to finalize their rule against non-competes in the workplace. They do several things here with this vote, is that they say that existing non-competes are no longer enforceable. Future non-competes can no longer be put into place. It does allow for senior executives that earn more than $150,164 to continue using the non-competes that is previously in there as well. However, there are a couple of positions that you have to think about. The qualifier they put in there about a policy making position. So typically that individual who is going to be making over a certain amount and is in a policy making position is going to be among your most senior executives, which still means you are barred from using non-competes in some other areas as well. We wanted to not only take a look at the non-competes, which have gotten most of the headlines, but also part of the NDAs and what the language said with regards to non-solicitations. They are saying that NDAs, non-disclosure agreements, which many of our members have even more so than non-competes, they could be a non-compete for functions to prevent the individual from being able to move on or leave their job or starting their business. With regards to this new rule, please keep focusing on how the administration is looking quite a bit on starting a new business and how this rule would generate thousands of new business owners. That is a lot of where they're heading with this rule, is saying not only does it keep this from being a lateral move and you going to join a competitor, but also the NDAs and non-competes and non-solicitations and TARPs have prevented individuals from starting new businesses and new initiatives and new innovation that's out there. So the way that they're looking at the NDAs is they will allow you to have an NDA that's in place that is a garden variety NDA, that the worker agrees not to disclose certain confidential information to a competitor that would not prevent but as long as it doesn't prevent that worker from actually moving, and that is so broadly written that for practical purposes, they do actually function to prevent that worker for going for another employer in that field. So again, you can't have them barring from learning anything or disclosing rather anything whatsoever that they learned in their employment, but that especially means anything that's already publicly available. And that's here where you can see a garden variety NDA where the worker agrees not to disclose certain confidential information to a competitor would not prevent them from seeking work with a competitor. So that kind of an NDA seems to still be okay for those purposes as well. When we look at the non-solicitations, and this one I was with a manufacturer recently, and it came up where he said he just has his employees say for 2 years, you will not solicit any of my customers. So this is a little bit different than from taking my know-how, but taking my customers. And in this case, they are saying that certain non-solicitation agreements may be non-competes under the final rule, because in some ways they could prevent them from moving on and seeking or accepting other work or starting a business after their employment ends. So you have to be careful about how it's written. If the terms that do not necessarily affect or prevent them from seeking or accepting other work or starting a business, then it's okay. But again, it's a little bit vague in terms of how you would actually start to meet that threshold. So on the non-competes and FDAs, or excuse me, NDAs, and non-solicitations, watch the space closely. The lawsuits have already begun. The U.S. Chamber, among other groups, have filed. We'd be surprised if this rule took effect prior to the election in November, but you do want to keep in mind that a number of states are already moving forward, and you have to be careful and track the state in which you're operating for those kinds of rules that are already applying in the interim as the courts work this one out. Investor advisory fiduciary rule, something we worked on back in 2015. It's been a number of years, but again, largely deals with small business advisory roles. So folks that are giving you advice, don't be surprised if you hear from one of your financial advisors about new disclosures. That is what it's related for there. This slide and the next one are for especially your HR folks to be sure that we've got 2 new updated guidance that just came out in the last few weeks here from the Equal Employment Opportunity Commission on harassment enforcement guidance. And what they did, especially when you go to this link, there's another section under B2. And if you go under B2, that'll give you a little bit more details on some of the different covered and legal protected characteristics under what constitutes harassment and the steps that need to be satisfied with regards to some of those terms and conditions of employment and when liability is found. So EEOC just updated harassment claims under different levels of harassment as well. So this applies across different types of offenses there as well. We brought this up last year with regards to the EEOC's pregnant worker fairness rule implementation and the new rule with the requirements that came in on April 15th. EEOC did put out their final rule. We did preview the one previously. Some things to keep in mind in here, it does go towards reasonable accommodations, including restroom breaks, liquid intake, whatever water breaks, seating breaks, other accommodations that you can obviously assume what could be reasonable, but they do get very, very specific in this final rule. And so if you do have an individual that is pregnant or may become pregnant, it is going to be wise to review the updated guidelines in here that was just released on April 15th, as it is a final rule and does get very specific in the examples and could be helpful for all parties involved as well. Final nail in the coffin in the association health plans, not a surprise here. We previewed this previously. This we had worked on, both groups have in the past, on allowing small businesses to pool their resources to lower the price of healthcare, and that was opposed by the Obama folks, endorsed by the Trump folks, and here we are again, Biden folks changing the definition to say, no, you cannot move forward with those. This one for your HR folks, again, just make sure that if you've got somebody that's coming into your shop saying the Department of Justice just legalized cannabis, you tell them no, that is not actually what is happening. I'll be speaking to the PMA HR roundtable here in a few weeks, and we'll be clarifying as well what changes that this makes as well. No, this does not change the status of marijuana with regards of taking effect immediately under the DEA. This does not have an immediate effect in terms of the public aspect. There's going to be a lot of changes with regards to rescheduling that takes some time, and a lot of it starts with research and all that. So decriminalization, that has not happened, that did not happen. And for your HR folks, if somebody tries to feed you that, there's your slide that tells you otherwise. EPA, a couple of regulatory items.
Omar, let me jump in there. There is bipartisan support, not for decriminalizing, but allowing credit card uses for the use of cannabis. And they can't do that until the Department of Justice moves forward. As I say, there's bipartisan support to move a marijuana bill in the Senate, but I don't think they have 60 votes. Back to you.
Yeah, back to items that are relevant to our topic. EPA GHG power plant standard, that's been final. This is important as this goes back and rolls back some of the Trump era policies on the Affordable Clean Energy standard that they put out. So expect to get lawsuits with regards to this. What they did is a number of things with regards to the power plants, especially those that are moving forward with regards to some types of new technologies for carbon capture. They're giving a little bit of leeway and saying facilities that you do not plan on putting anything towards some and making any transitions to your sources and your carbon capture technologies, you're allowed to run up until a certain year, and then you can shut down and then you can cease operations by 2032, for example, Others where you are going to be able to reduce the standard by 90% of capturing your CO2 can continue to operate through 2039. Again, all this is subject to the next regulator that could come in if there's a change in administration, but just note that those rules are continuing to rush through. And to Paul's point previously, you're seeing this flood of regulatory activity due in large part because you've got the Congressional Review Act that the deadline is coming up here for regulators to issue rules and regulations without having them being subject to congressional direct oversight and potential reversal and permanent blocking, which could happen sometime, they're saying, after June, or late May, early June or so could be that date after which anything that is passed by or moved by a regulator could be subject to an up or down vote on Capitol Hill, and a signature by a president if Trump comes in could override. 2 items here on 48C, as now the round 2 is open on federal dollars. For some of you all that have clean energy manufacturing projects, especially those that have applied last summer. We know had a couple of manufacturers that did do that. And what from that standpoint, they fell short. You are permitted to reapply, and we strongly encourage you to do so. Primarily, if you are listening to this, you probably received a letter that outlined the reasons that you did not were accepted into this program to apply for the credits from the IRS after the Department of Energy approved you, but there's billions of dollars at stake. Again, if you're doing any kind of retrofitting, particularly if it involves any heat capture and lowering the amount of heat generated and used and emitted, there's federal dollars that are out there with an FAQ that was just released. There'll be a webinar as well that's coming out, but similar, it mimics a lot of what they did last year as well. Also from the RFI standpoint, we had a conversation with some folks last year about wind turbines, if you're making components for that, and the reason they're still coming over from Western Europe, and the areas in New Jersey haven't taken off, but the federal government is trying to get a better handle on that as well, in particular because they are trying to not only put in the renewable energies, but they are trying to change the environmental review laws such as NEPA. This is the National Environmental Policy Act that allows them to expedite infrastructure and utility and renewable energy projects in order to move forward. And that's with the wind rule. They're finding a lot of challenges, especially with offshore wind, being able to find the blades facility that can manufacture and then ship into a waterway to get it to the location it needs to go. But under the new NEPA rule that's complete, they are looking at changing the process, and they can accelerate reviews for certain projects. And they're saying they're going to increase the use of categorical exclusions, which basically means these are projects that we believe are not subject to the rule. And so we'll watch that space closely. I'm sure the folks over at Bracewell have a lot of expertise that they can shoot something over as that further gets into effect and how that works out, and if that will in fact increase some utility projects bringing more energy online. Speaking of which, this one could affect some folks on methylene chloride. From what we understand, and you all have told us, this is used in a number of areas, obviously degreasing, but also in terms of metal cutting and for surface cleaning with regards to metallurgical metal uses. And so something to watch with regards to EPA banning most use of methylene chloride, with a few exceptions that you can see down at the bottom: plastic and rubber manufacturing and a few other unsolvent welding. But as it relates to at least some of the cutting of metals and the use of methylene chloride, it does look like the EPA is moving forward with the timeline to ban even that sort of industrial use, and watching out there. The last slides here on regulatory, we're not going to run through because this is a proposed rule, but something just to flag that the Cybersecurity and Infrastructure Security Agency, CISA, which is part of the Department of Homeland Security, on March 27th and then published on April 4th, a rule that would cover certain manufacturing sectors that would require the reporting of a cybersecurity incident reported to CISA no later than 72 hours after the incident occurs. And if you have to pay a ransom payment, or someone or insurance company pays that ransom on your behalf, that has to be reported within 24 hours to CISA as well. You have to keep your records of any incident that has occurred for 2 years following after you reported that to CISA as well. That's something to factor in. There is a small business exception here, and they are following the SBA definition, but then they also have a qualifier saying that if you are part of one of the identified industries, that it doesn't matter the size you are still a covered entity for purposes of reporting requirements. And also for us association folks, it does include associations as covered entities, and they're still trying to seek clarification on that. So even if you are under, say, 500 or 750 employees, or even 1,000 if you're not a motive stamper, you are still potentially a covered entity if you do fall under. So particularly some of our machine shops, our tool and die folks, our machinery equipment manufacturers under subsection 333 of your NAICS codes, those are considered covered and critical to the manufacturing sector and would be a covered entity for purposes of this proposed rule. Similarly, on the defense industrial base sector, not a surprise there as well. They also give an example: if you do some parts for defense or some parts for a covered entity and then some others for not, or if you have multiple facilities, the whole company is covered. So if they see if there's a breach on one side and you do some medical device, but on the other you don't do any medical device, all of it needs to be reported to CISA if and when this final rule goes through. And they estimate a $2.6 billion cost with over 300,000 companies and entities rather that would be required to comply with that. A lot of that they're claiming is the upfront cost, but again, just keep in mind how that might go there. But Paul, let's just go ahead and transition over a little bit to trade as we get ready to wrap up here.
Sure. Thanks, Omar. As most of you know, President Biden recently proposed in a speech to the steelworkers in Pennsylvania on a campaign stop that he is going to urge USTR to consider tripling the existing 301 tariff rate on Chinese steel and aluminum. The current rate is 7.5, so you know it would so he would greatly raise that. You know, from a practical level, specifically, the United States doesn't use it a ton of Chinese steel anymore because it is about 9 or 10 on the import list, only because there's a lot of anti-dumping duties and other protections that dissuade users from importing directly from China. However, as we have talked about very often on this webinar, when you put up more and more protections of steel, imported steel, and there is no competition from the domestic industry, that tends to create a island of high steel prices in the United States, particularly because many of the products that we make, or almost all the products we make, have no tariffs or protections against them. So we always want to remind the administration that protecting one side of the supply chain and not the other is not a good economic policy. You can see I was quoted in the New York Times last week on that very point in my capacity as the Coalition of American Metal Manufacturers and Users Executive Director, which both NTMA and PMA are founding members. You know, that Biden administration's complaints about the Trump administration's 301 tariffs were that they were just too across the board in one level, and that they should be much higher in specific product categories. Not that there are too many or that there shouldn't be tariffs, just that the way that they were applied wasn't very strategic. So I think you'll see much more of that as we continue to move forward in the discussions about China. You know, obviously we all agree that China overcapacity in the steel producing sector is a big problem, and encourage the United States to work with our trade partners and national security allies to address it, instead of trying to unilaterally address it through tariffs alone without coordination, which has not resulted in success both historically and in the more recent past.
Yeah, no, I agreed. And with regards to that, you're going to continue to see, regardless, of the rest of the year, how it works out, additional focus on tariffs. We do note the U.S. International Trade Commission, an independent federal agency, part of the U.S. government, is continuing to work on its survey to identify the greenhouse gas emissions coming from U.S. steel and aluminum industries, and also from aluminum castings and aluminum forgings. The hope being that if there's a second Biden administration, from their standpoint, they would use the information gathered on the carbon footprint of these industries to create a baseline for U.S. industries and apply a carbon-based tariff on imports coming in from overseas. The preliminary company level reports were due on April 22nd to I think 22nd or 23rd, and they've got facility level reports that are coming up due next month, as well as part of the report that is due in January of next year to the U.S. Trade Representative, that will then inform the decision on whether or not to move forward with some kind of a carbon-based tariff on that material. And to Paul's point there, with regards to the tripling of steel and aluminum tariffs, the way that they're looking at doing this is through the Section 301 existing process that former President Trump had put in place on list 1, 2, and 3, and then also 4A. What they would do is basically go into the existing line items or see if they add more during part of the ongoing 4-year review that's required by law, and then they would be able to increase it under that. So they're not looking at doing a new action, they're going to expand a current action. Seems to be the simplest and most efficient way for them to do that, and the president on April 17th instructed his U.S. trade representative to do so. She is moving forward, we believe, by the end of this month with possibly releasing the report that does go back and review the impact on the economy of those Section 301 tariffs of 25% on 6,800 imports from China and 7.5% on 3,200 imports coming in from China. And that report coming in at the end of the month would coincide with the expiration of existing exclusions that are still left in place. So we could see some kind of action on the tripling of these tariffs and some other announcement with regards to the 301 review sometime later this month. And similar, on the same day, we did see President Biden also talk about his team already working with Mexico on transshipment and tariff evasion coming in through Mexico. And we expect to see an announcement. We had expected to see something by the end of April, but we sometime here in the coming month or so as well. Similarly, as part of those announcements the other week, the U.S. Trade Representative announced it's doing an investigation not only in Chinese shipbuilding, but also in logistics management and the involvement, as you've seen now that China is manufacturing the majority of the wide hull ships that are out there moving product around the world, in addition, obviously, to the containers that they've been manufacturing for 2 decades. And so they're looking at those market disoriented policies that are coming out from that standpoint. As well, as we get ready to wrap up, please do enter in any questions you've got on the right-hand side. We've got a couple in here. We'll go ahead and answer here in a moment. But as always, please do listen to our podcast where we get into a little bit more on the political side of things. And we'll be recording one here in the next week and posting that shortly. Talking with One Voice, you can find that on wherever you find your podcast. Please, as always, do donate, do support us however you can at any level you feel comfortable doing so to both PMA and NTMA, and those links are provided here. Again, please feel free to type in any questions on the right-hand side. I know we covered quite a bit today, and one of the questions was, will the slideshow be available immediately following the webinar? We'll use the term immediately slightly loosely, as yes, within the next couple of hours. Normally it is sent around, and we will also post it as well with the webinar in addition to the slide deck. The other question was, any action scheduled on the Senate Finance Committee on the recently marked up Ways and Means bills? And we'll put that in context. On April 18th, I believe it was, April 17th, the House Ways and Means Committee passed, and through what we call a markup, 6 different bills that are related to trade. Several of them are of a consequence to our membership and our industries, and they've only moved through the committee, and they've only done so largely along party lines, meaning only Republican votes. One of them is the de minimis rule, and that one allows for products to come into the United States tariff, tax, and duty free if they are valued at under $800 or less per shipment. That used to be at $200 until a law was signed in 2015 and took effect in 2016 that raised it from $200 to $800. So what others would do from China and elsewhere would be to split up shipments. So the value then would be below $800 and they'd get it in that way tariff free. The bill passed by committee would bar any goods eligible for duty free under de minimis if they're on the 301 list, the 232 list, or the 201 list, meaning steel, solar, aluminum, or those thousands of goods I mentioned coming in from China. The other bill that they mentioned deals with Generalized System of Preferences, GSP, and that deals with 119 designated countries and territories that are developing that also receive duty-free treatment on thousands of products that come in. That program expired in December of 2020, and since January of 2021, companies have been paying duties on that. The legislation passed retroactively reinstates and makes individuals whole for those 119 countries and keeps the program going through December of 2030. It does, however, have a number of restrictions with regards to any countries that have significant advanced military ties and other advanced economic ties with China in certain categories, and they would no longer be eligible for GSP. The issue is, though, and a few others did not make it on here, miscellaneous tariff bill was not introduced in time and had not been addressed, and then the Democrats all voted no, mostly all no, for a couple of reasons, one being procedurally and the other being trade adjustment assistance. The trade adjustment assistance, this is the one Democrats always ask for, usually as part of trade promotion authority, meaning a new trade agreement. negotiating authority for the president. Republicans are saying no to trade adjustment assistance because they believe it should be linked to a TPA, and it's not big enough, right? They're talking about on GSP, MTB, and some of the other issues in order to move it. And so Republicans are saying no on TAA. Democrats are saying no on any type of trade bill unless they get trade adjustment assistance for workers, that it helps assist former employees that have been adversely affected by imports and by tariff policy to go get retraining and other assistance. That's what trade adjustment assistance is for firms. There's also TAA for workers, or for firms rather, and the other one is for workers. What they have for firms is also similarly just assistance for those that have been adversely affected by trade. It's my understanding, based on a conversation I had on Thursday morning with the Ways and Means Committee staffer, is that this is still going to be tied up. We do not expect any action on trade bills through until we get past the election. Since the bills have not come to the House floor, we do not have an indication that these will go straight to the floor. They're likely in a holding position, which means TAA for workers, TAA for firms, GSP, and all the other ones are tied together likely until after the election. Long explanation, but with that background, we do not expect to see any movement unless Republicans give ground on TAA, and we don't expect them to do that unless Democrats really see to be more flexible in other areas. There's also a long way of buying some more time for any other questions that came up that we could answer. Seeing none, thank you all. Our next webinar is going to be Friday, May the 31st at noon Eastern. In the interim, you have our contact as always. Please reach out to myself, John Bracewell, Jenny at NTMA, or Christy at PMA. Thank you all. Talk next month.